case on this morning's docket. That is case number 110280, State of Kansas v. Redmond.
Mr. Chief Justice, and may it please the Court, I'm Brett Watson, Assistant District Attorney with the Shawnee County District Attorney's Office, representing the appellant, the State of Kansas. May I please reserve 2 minutes for rebuttal?
2 minutes is granted.
Thank you. The table has somewhat been set with the earlier argument, and I don't wish to duplicate many of the arguments that were already made. There's plenty of room here for further discussion on some of these points.
Let's clarify one point that with regard to the CORA, we had the rationalization that sex offenders are just a different category of convicts, but CORA applies to much more than just sex offenders, does it not?
That's correct. In subsequent amendments since the original enactment of the Kansas Offender Registration Act, the legislature has added drug offenders and violent offenders, those drug offenders being people convicted of distributing or possessing with intent to distribute opiates, which would include methamphetamine and cocaine, and obviously certain qualifying violent felonies such as kidnapping or homicide offenses. That case obviously isn't before the court, or the precise question of whether or not retroactive application of offender registration to those kinds of offenders is not before the court. In this case, Mr. Redmond was convicted in 2001 and sentenced in early 2002 for a conviction of indecent solicitation of a child. At the time, CORA existed, and at the time, Mr. Redmond was required to register under that act exactly four times a year, although in-person reporting was not required at that point in time. The legislature subsequently changed the law, and when Mr. Redmond was initially convicted, the period of registration was for 10 years. Subsequently, in 2006 and 2011, the legislature amended the act that changed the requirements in certain ways for Mr. Redmond. Those are the issues that are before the court. They include the duration of the period of registration, which was moved up to 25 years. And a subsequent legislative enactment also required in-person reporting as opposed to mail-in reporting. There are a few other issues regarding the changes that I will discuss. I think those are some of the major ones. But obviously the position of the state in this case is that the district court below in this case erred in granting the defendant's motion to dismiss.
Let me see if I can summarize where we are. The defendant completed the period of registration that he was originally ordered to do, correct?
That's correct.
And then he was convicted of 3 serious felonies for not registering past that original period. Are
you referring to convictions in this case,
right.
Judge? No, that's not correct. The defendant's motion to dismiss was granted.
Oh, okay.
Before
He was charged with 3 serious felonies.
Yes, pre-trial the court granted.
And your argument is that that's not punitive. That's where I'm headed. And your argument is that that's not punitive.
Yes, may I pick up my pen? I apologize.
Sure.
Thank you, Mr. Daisy. Yes, our argument is that the district court erred because obviously, as the court is aware, the law on this subject is the retroactive application of a law does not apply or is permitted if the law is non-punitive, if that's the legislative purpose. Although, despite the fact that a legislature might articulate a non-punitive purpose, the courts can find that the law is in effect or purpose so punitive as to override the legislative intent.
Let me deal with that. You just said that the legislature can declare that a statute is non-punitive, but they did not do that here, did they? There was nowhere in the CORA language itself that says it's for public safety purposes.
That is correct, and that was also the way the court recognized, or that's what the court recognized in the Myers decision.
And that's also a distinction between the Alaska statute that was in play in Smith v. Doe.
I'm not aware, actually, if that's a distinction between the Alaska statute and the Kansas statute. It might be that the Alaska statute had a explicit statement of purpose.
There was an explicit statement, and also part of the registration requirement was contained in a section of the statutes that was not the criminal code.
The health and safety code. I recall that part of the opinion.
But here we have the entire registration, CORA, is contained in the criminal code.
Yes.
And there's no statement that this is for a non-punitive purpose or any purposes stated.
Yes.
Not stated.
And let me address those points.
Okay.
As to the first one, in this case, the state is relying on precedent for the conclusion that there is a non-punitive purpose. That was the determination that was made in Meyer, and we believe that the law still has that regulatory purpose, and we believe that's still good law. Obviously, the precise question in this case is not whether or not CORA is punitive or non-punitive, but the specific statutes that were applied retroactively, which would have been the increase in the duration of the registration period, the $20 fee, et cetera, et cetera. But as to the overall principle, we're relying on the Meyer decision, and we believe the court will uphold that, or at least that's what we submit. As to your second point, and that obviously addresses the issue of there being no explicit statutory purpose. There wasn't in 1996, but the court found that the legislature's purpose was non-punitive. The question of purpose becomes a little bit more focused when we get into the Mendoza factors, but I'll address that in a moment. As to the second point that you were making, which was in regard to where the statutes are located, where the laws basically, or the statutes are located in the reporter books. This I don't believe this is on the record necessarily, but in point of fact, I don't believe that's indicative of legislative purpose. Because the determination of where bills passed by the legislature actually goes in the statute book is not made by the legislature. It's made by the Reviser of Statutes office. So when the CORA was initially passed, a bill was passed. The Reviser's office decided this fits best into 22, which is criminal procedure. And then the subsequent amendments have been to the statutes in Article 22. So we do not believe that that constitutes an indication that the legislature has changed its intention to move from a regulatory purpose to a punitive purpose. But moving on to the heart of the arguments, the court is well aware of these points, and I won't go through them individually because there's not the time for it. But one point that was discussed in the previous case, but not to any great degree, and which had an effect upon the district court's decision in this case, which we believe is distinguishable, which the Appellee argues is evidence of a legislative or punitive, in effect, CORA now, are the penalties for violating CORA. That is, the legislature has from time to time changed the penalties from a misdemeanor to a non-person felony, then to a level 5 person felony, and now they remain a level 6, 5, or 3 person felony, depending upon whether or not you have prior convictions. And currently, the way the law is written, failure to pay the $20 fee is a non-person misdemeanor. The state submits that this is not relevant to the analysis of whether or not these subsequent legislative enactments are punitive in nature for several different reasons. One is the state recognized, or this court recognized, the same in State versus Cook, where the defendant challenged on ex post facto grounds his conviction for a violation of the Kansas Offender Registration Act, which was a level 5 person felony. Arguing that at the time that he had actually received the duty to register, CORA had been a level 10 non-person felony. The court there found that the violation or the increase in severity level of the crime was not relevant to ex post facto analysis. The court in Doe also made the same determination, saying that the act of violating the Offender Registration Act always happens prospectively. So it's not relevant to whether or not the duty to register, which is what the relevant question is punitive or non-punitive. In this case, we submit that the real question is whether or not having to go in person to the sheriff's office to register, having to pay the $20 fee. There's also an allegation, I don't believe it was made in the court below, but it's made on the Appellee's brief about information on the driver's license. If that has somehow rendered the law punitive in effect or contrary to the regulatory purpose of the law.
Can I take you back to your irrelevant on the violation penalties? Why isn't it relevant to legislative intent, whether the legislature intended this to be punitive, the penalty that it set up to enforce?
For two reasons, Judge. The first is, like we say, or like I was arguing before, those violations only work prospectively. We never go back and say that you must be subjected to the penalty section for a core violation happening at an earlier time.
I understand that argument, but do you understand my question?
I do understand your question. That's my first argument. The second answer is, and I understand more to the question of legislative intent, the penalty changes, or the changes in penalty, the state's argument is anyway, is to enforce compliance with the Registration Act. That's what the purpose is, and in that sense to enforce compliance or to achieve the legislative goal that CORA is trying to achieve. There was some discussion about this in the last argument regarding the purpose of CORA, and there was a question, I believe, that you asked, Justice, which was if the information about a person's prior sex conviction is a public record, which it would be in this case, because a conviction of this kind happens in open court. It's a non-expungible offense. It is the kind of thing that an employer could ask about and an employee or an applicant would be required to answer. It is the kind of thing that a potential landlord might be lawfully able to ask, have you been convicted of a felony or have you been convicted of a sex felony? The actual convictions themselves are obviously not secrets. But the question that was asked of the other person making the argument was what was the need for the law in and of itself if that information is already in the public domain. The purpose of the CORA obviously is, and there has been a determination made by the legislature that the court upheld or understood or recognized in Meyer, is that there's a high degree of recidivism and danger posed by people who have certain qualifying sex crime convictions, such as the one in this case, indecent solicitation of a child. Now, obviously, the purpose of the CORA is, so for public safety purposes and for law enforcement purposes, the people who are convicted of these kinds of crimes, their whereabouts, their location, where they are, what they're doing, as far as employment or school is concerned, is known by the public and known by law enforcement. So getting back to the earlier question you were asking, as far as the increase in severity level for those offenses, it's our position that the reason why is because the legislature wishes to have this law obeyed in order to get the benefit of knowing where these people are, where they're residing, and where they're working.
Okay, we're talking about the 2011 amendments.
Yes.
Mainly. And I understand we are dealing with a sex offender in this case, but those amendments also apply to drug dealers or someone that used a deadly weapon in a robbery or whatever. So how can you argue that the legislative purpose is tied to the danger and recidivism of sex offenders when the law is broader than that?
To answer your question, Judge, I would say that obviously, as I said before, should that case come before the court might reach a different outcome than we're asking for in this particular case.
But the Mendoza factor is whether that it's, we look at the connection to non-punitive purposes. So we have to assign a purpose for CORA.
Yes.
And I'm saying, how can we carve out just some of the people to which it applies as providing the rationale, the legislative purpose?
I see my time has expired. May I take time to answer this question?
We'll insist on it.
Thank you. The answer is that the Mendoza factors that we're talking about apply as part of a two-step analysis. The first question being, did the legislature have a non-punitive purpose in mind? The second question being that if the purpose is non-punitive, is the law, according to these factors the court looks at, so punitive in effect that we're going to override or disregard what the legislature's original intention was? And the factors as they're described, not necessarily in the Mendoza case, but in the Smith versus Doe case, all refer to whether or not there is a rational connection between the non-punitive stated purpose and the disability or the obstacle or whatever obligation is imposed by the retroactively applied law. So our argument would be that although reasonable minds might disagree about the potential danger that drug dealers and violent criminals, murderers, and kidnappers pose, as compared to sex offenders, it's not irrational for the legislature to reach the conclusion that, like sex offenders, having the whereabouts of these other kinds of offenders would promote a public safety purpose. So then the question would be whether or not the obligations that are imposed by CORE, when they're retroactively applied, are rationally related to that purpose. And obviously, our contention is that they are, because increase in duration of registration promotes the public safety interest by increasing the period of time in which the offender has to notify law enforcement about their whereabouts, or whether they leave the county, or whether they change residences, whether they're transient, or whether they have come into our state from another state with a qualifying conviction. As well, the requirement of actually registering in person is rationally related to that non-punitive purpose. And this was something that was pointed out in the First Circuit case that we cite in our brief, which is the actual requirement of having someone physically come into the sheriff's office is, at least to some degree, a greater way to ensure that the person in question is actually physically located in that county, as opposed to allowing them to register by mail where, in that scenario, they may be in the county, they may be elsewhere. It's not entirely clear. The burden that this places upon the individual, we submit, is relatively small in light of the regulatory aim that we're trying to achieve here. Because as CORE works, a person 4 times a year has at any one point during one of those calendar months to come into the sheriff's office and to fill out some paperwork in person. They don't necessarily have to do it on a particular day. They have a wide period of time to do that. Obviously,
that's simplistic. If they work in a different location, if they go to school in a different location, it's potentially 12 times a year that they'll have to show up in 12 different locations.
That's correct, Your Honor.
And
however,
pay $20 at each place.
The point that we would make in that scenario, however, is that the public safety interest is greater in that set of circumstances, because obviously a person whose whereabouts, whose employment or school is located in a different county in which they reside, pose a greater degree of public safety danger than the person that resides in the same county and works in the same county. But, and I don't want to go on forever, but there is one last thing I'd like to point out, if I may, Your Honor, that I think is relevant to your question.
I'm going to have a question for you when you're done responding, so yes, please continue.
I think that point is addressed in a very straightforward way in the Doe decision, because, and this was talked about in the previous oral argument, when we're talking about the actual restraint or disability placed upon the person as a result of in-person reporting. It is true that the Doe decision involved an Alaska statute that did not require in-person reporting. That did not have to be done in that way, whereas Kansas is different in that regard. However, one of the things that the court pointed out in that case is that they were rejecting the reasoning of the Court of Appeals below them, which found that the requirement to report in person is incredibly onerous and it's akin to probation. The court said, no, it's not. The act of registering, even if it's done by mail and not necessarily in person, is nowhere near that onerous. We have a similar situation, and that comparison can be used to compare or consider our Kansas CORE statute. Because the requirement to register in person, although it does physically require a person at one point during the month to physically go to a place to register, is nowhere near as onerous as the requirements of supervision, for example, where a person will have to report on multiple occasions, where a person is prohibited from what establishments they can go into regarding the sale of alcohol, where a person may be prohibited from when and where they can be outside of their home with curfew restrictions. There are all sorts of greater restraints that are placed in a situation like that, which when considered in context, we argue anyway, make the obligation to go in physically and report to the sheriff a relatively small burden when compared with the public safety benefit we get from that requirement.
Counsel, what year was Myers decided?
1996.
And if my notes are correct, as of that time, sex offenders were covered by what was then called the Sex Offender Registration Act, which later became CORA. Is that right?
That's correct.
So in 1997, the legislature amended the act to now include persons convicted of specified violent crimes. Is that right?
That may well be, Judge. I don't know for sure. I haven't looked close enough at it. If you see that somewhere, I don't have reason to question that.
And then in 2007, the legislature again broadened the act to now include persons convicted of specified drug crimes.
That is correct.
Okay. So if we have a 1996 decision in Myers that basically, as you have said, the purpose of the act is non-punitive.
Yes.
And since that decision, the legislature has now added 2 different categories of people who are fitting under the CORA requirements. Can you tell me whether that impacts your analysis at all when you're telling us today that it still is not punitive?
It may impact the court's analysis, but the position of the state is that the purpose, the public safety purpose, is still the apparent purpose or the inherent purpose in the law. This goes back to an answer I was giving a few moments ago. As I was saying, it's not irrational for the legislature to reach a conclusion that certain other offenders pose a similar threat to public safety to the point where having their whereabouts recorded and requiring them to register is something that provides that same benefit in the same way as sex offenders. The court may choose to revisit that question. The district court did not revisit the question in this particular case. The district court's decision was based upon a determination that although the legislation is non-punitive in purpose, its punitive effects exceed that. But obviously, our contention is that the stated purpose, at least for sex offenders such as Mr. Redmond, are the same as they were in 1996.
Do you have an opinion on where the legislature would be forced to stop
As far
in terms
as,
of specifying categories of offenders who would then be subject to these requirements?
as far as ex post facto analysis, Judge, that might be different from a question about where the legislature would be forced to stop in just passing legislation. Obviously, laying aside other legal challenges, due process or what have you, the legislature, I suppose, if it wanted, could make all convicted felons register under similar circumstances. I think that the legislature itself would be prohibited from doing that just based on a combination of common sense and cost-benefit analysis. Because we have, speaking as a prosecutor, we have a high degree of recidivism and danger that arises from people who have been convicted of certain drug offenses that involve distribution of certain controlled substances. And certainly, I think it's rational to say that once a person has committed a certain qualifying violent offense, such as kidnapping or homicide offense, they pose a particular danger. I doubt very seriously whether the legislature would say we need to know where all the felon thefts are, we need to know who all the people who commit the crime of criminal commercial fossil hunting are, because it's just not going to achieve any meaningful goal for the state.
So it would be your position, however, the legislature would not be prohibited from expanding those categories and therefore requiring people of those, I'll just say, lower offenses from all the CORA registration notification requirements.
I think that would obviously present a different challenge if the question were to be the retroactive application of those registration requirements.
You don't believe that expanding those categories has anything to do with our determination of whether the registration requirements under CORA are meant to be punitive or non-punitive?
That's not what I'm saying. I'm just saying that in a challenge like that, obviously the only way it comes up is if you're considering the retroactive application of that potential hypothetical registration requirement.
All right, thank you. Any more questions?
Just real quick, where Justice Johnson started this case arises from a 2001 conviction, as I understand it, in December. and the statute was amended and I probably became effective July 2011. Is that accurate? I don't want to get into the defenses that could be raised on the 3 subsequent charges of failure to register, but he basically served 9 years and 7 months of the 10 years. The statute comes into effect. Do you know if he was notified at all of the change?
I don't know. I don't want to speculate because I don't know.
And I appreciate that, but might not be the question for this particular case because it gets into a defense that could be raised perhaps on the 3 other charges, but that's the posture, is that
I do understand.
9 years, 7 months after he's done the 10 years, statute gets changed, and then he doesn't register after the 10 years has lapsed.
That's correct. We don't have facts in the record that can answer your question. I can't answer your question without speculating about the only thing that
I don't want speculation. That's all.
That I won't.
Okay, thank you.
Any further questions? Yes.
Just a short one,
Sure.
Chief. I apologize. I'm not talking about the retroactivity, but you're talking about the rational basis of the legislature, and I certainly appreciate that. But there was a rational basis earlier that it was X number of years, and then later, well, are you saying that how does the rational basis change with the duration?
In reality, one of the ways that this is influenced is by federal legislative action. Our periods of registration will sometimes be changed because the federal government
So it wasn't a rational basis, it was to try to come into compliance with the Federal Act then. I mean, you talked about the legislative rationalization.
Yeah, and the only thing I would take issue with in that characterization is that it sort of implies that the federal government is recommending that the states increase their registration period for an irrational reason, assuming that the federal government hasn't done policy study groups or things of that nature and come to a rational conclusion that that period of registration would be better.
Right.
Obviously, again, in this particular case, somewhat similar to the one before it, we don't have live testimony or that information that is in the record. But that's the only thing that I would quibble about as far as the point is I think it's perfectly rational for what the legislature did in 1996. It's not irrational that the legislature chose to extend the registration period.
Well, extend it and then relate it back.
Yes, Your Honor.
Right. Okay.
Failure to comply is the rational basis. And the fact that there are consequences of failure to bring your state law into compliance with the federal law can be a rational basis, whether the federal law was rational or not, can't it?
That's a good point, yes.
Any further questions? Thank you, counsel.
Good morning. May it please the court. Jeffrey Daisy on behalf of the Appellee, Mr. Promise Redmond. Like a bolt out of the blue, I can think of no more appropriate way to characterize Mr. Redmond's reaction to learning that he wouldn't have to register for 5 more years. He wouldn't have to register for 10 more years. He was going to have to register for 15 more years.
When did the bolt hit him?
That bolt hit, and it's not clear, but I'm glad you asked the question, Your Honor, because today there are no defenses available to registration. It is a strict liability offense. The question is simple. Did he register in that month, or did he not register in that month? I think that factors directly into this court's analysis of whether the effects of the Registration Act retroactively applied upon Mr. Redmond are punitive. That bolt would have hit somewhere between July 2011 and I'm estimating here because it's not in the record. Late 2011. As the court noted, and the record reflects, Mr. Redmond's original registration term would have expired on December 13th, 2011. That was the date that he was sentenced. Mr. Redmond's charges for violating the Offender Registration Act all came subsequent to what would have been the expiration of his term of offender registration. But this is a young man who completed his probation term. This is a young man who has remained in the public, albeit socially isolated. Mr. Redmond has stayed out of trouble. You can search public access, court records. Records of our convictions are publicly available. And he has done so throughout the 10 years that he has been required to register under CORA. So like a bolt out of the blue, this expansion of its registration requirements hit him. Of course, the court's probably aware that language comes from State v. Cook. And it comes within the context of this court's discussion of the purposes of the ex post facto clause. This court then immediately cites the language from Weaver, that the lack of fair notice and governmental restraint is the critical factor in granting relief under the ex post facto clause. I think this language from Weaver hits directly on the concerns that have come out of this court during oral argument today, especially as it relates to the ever-expanding net that the state of Kansas has cast to capture as many offenders as it possibly can, and then to impose the continuing obligations of offender registration upon those offenders. It's not just sex offenders anymore. It's drug offenders, it's violent offenders. Perhaps the legislature does have the power to enact registration schemes that broaden those categories and that do so, but not without restraint. And that's where the ex post facto clause serves as such a critical protection. The power of the legislature to criminalize or require registration for broad classes of criminals and then retroactively apply it. It's already before this court, or at least it could be. State v. Simmons addresses a similar claim. I think there's a petition for review pending in that matter. But it does involve an offender who, when convicted of their drug offense, was not required to register, but through the act of retroactive application has so been required. All of these concepts serve a critical purpose. Dare I say, an ancient purpose. These are not abstract concerns. They were written into the text of the Constitution. The framers of that document thought it wise to avoid even the amendment process and include the ex post facto clause along with a series of anti-retroactivity provisions. No less than John Marshall himself opined about that purpose. The framers of the Constitution viewed with some apprehension the violent acts which might grow out of the feelings of the moment, and that the people of the United States, in adopting the Constitution, manifested a determination to shield themselves and their property from the effects of those sudden and strong passions to which men are exposed.
How do we get to John Marshall through Smith versus Doe?
There's a direct link there, Your Honor, I believe. John Marshall is discussing in Fletcher v. Peck the ex post facto clause, or really the anti-retroactivity provisions that the ex post facto is contained within. Your Honor, it works in a couple of respects. the precise purposes that Marshall was discussing in Fletcher v. Peck are present here today.
Were they not present in Smith versus Doe?
They certainly were. However, the Smith v. Doe court adopted a framework, and the framework that has been discussed at length today. That's the precedential value in my position of Smith v. Doe. In fact, Smith v. Doe confirmed what this court had already done in terms of addressing these ex post facto claims. The analysis is, for better or worse, the Mendoza and Martinez factors. But what's important in those factors is that the court chose to utilize a factor test. This is a weighing procedure. At best, the precedential value for Smith v. Doe is to set a benchmark for what is constitutional. And that's assuming that this court would continue to give the same weight to the public safety purpose that the Smith v. Doe court gave it. So we're left now with a weighing procedure and a comparison and contrast. Is the Kansas Offender Registration Act, as it exists today and as it has been retroactively applied against Mr. Redmond, a violation of the ex post facto clause? Or, to phrase it in terms of the excessiveness inquiry, which was so important to the Smith v. Doe court, whether the regulatory means chosen are reasonable in light of the non-punitive purposes. That's the question. That's the most important factor. And it's a two-part weighing process. This court has to take into consideration the non-punitive objective, public notification at best. There has been discussion about the weight to be given public notification, the value of that non-punitive objective. In high school, I was a debater, and we had this concept called inherency. And I never really liked to go there, but I think that concept is applicable here today. When you were attacking someone's case and you were attacking it on grounds of inherency, your argument was, but whatever purpose this team is trying to achieve by proposing their policy or their program, that purpose is already being fulfilled in the status quo. They're just tinkering with it a little bit. They're just adding a little bit to it. The purpose here, public notification, is already largely being fulfilled in the status quo. We have transparent courts. We keep electronic records of convictions. It might be a little bit cumbersome, but it's all available, it's all accessible, and it's all visible. And that was part of the Doe v. Smith court's weighing when it discussed the punitive effects of public notification.
What about your opponent's point that just having open courts and public information about convictions is different in kind from knowing the whereabouts of people? And he says that furthers the public safety purpose in a way that just the information, the public record of conviction does not.
Perhaps it does. My concern is, though, that in doing so, the question is whether it's excessive, whether it's a reasonable means to fulfill that public notification purpose.
So it fails on the second question.
That's my position, and it's because of the onerous burdens that the Kansas Offender Registration Act has continued to force upon registrants. This court's discussed the continuing modifications to serial modifications to CORA, none of which, well, with the exception of one, have lessened those burdens upon the offender. It's always been it's been a consistently upward trajectory. You have to register more often. You have to register in person. You have to register 4 times a year. You have to register in potentially 3 different locations. And if you are transient, well, God should already have mercy on your soul, perhaps, but it's not going to get any easier if you have to comply with the Offender Registration Act. You have to register every 30 days. Movement, if you'd like to move to a different county, you may do so at your own risk, because you have to register within 3 days of your move in the county where you were residing. Then you have to register within 3 days of your arrival in the county where you propose to reside. These burdens, it's our position, outweigh the reasonable purpose of public safety and notification. If we're going to do a side-by-side comparison, and the most persuasive benchmark is perhaps the Alaska Offender Registration Scheme. Under that scheme, there was no in-person registration. In fact, there is in-person registration now in Alaska. You have to register in person once upon your arrival to the state of Alaska. And then, after that, you're in the clear. If you fit one classification of offenders, you have to register 4 times a year. And that was found to be excessive by Justice Ginsburg in her dissent. If you fit the other classification, you just have to register in writing 1 time a year. That was the act. That was the scheme that the Smith v. Doe court was considering when it determined that the burdens of registration were not so onerous as to overwhelm the non-punitive objective of the act.
And no fee.
No fee, Your Honor. No fee. So you have a spectrum of differences, all of which, under the Kansas Offender Registration Act, are harsher. In some instances, much harsher. A single violation of the Offender Registration Act today, as this court's aware, is a severity level 6 person felony. It exposes a registrant to between 46 months of incarceration, if they're an A, which isn't entirely uncommon, considering the types of offenses which require registration. Or, if you're low box and criminal history category I, it's 17 months. I want to leave the court with this thought. When Mr. Redmond was convicted and sentenced, the court imposed the aggravated term of 13 months. It was a severity level 7 person felony. Today, the charges that were dismissed against him were severity level 6 person felonies. What purpose is served by the enhancement of that penalty for a man who had otherwise been in compliance with the Offender Registration Act for 10 years? If the court has no further questions.
Any questions of counsel? Thank you.
Thank you.
You reserve 2 minutes for rebuttal.
Can you answer your opposing counsel's parting question?
Yes, as a matter of fact, that's what I wanted to start with. The purpose is people will comply with the CORA. They will fulfill their obligations to register. They'll let the local sheriff's office know where they are, where they're working, where they're going to school, and we will have that information. For a person that moves into a neighborhood with children, knowing that there is a convicted sex offender convicting of the crime of indecent solicitation of a child, for a person moving into an apartment building knowing that there is a convicted rapist living across the hall or in a dark corridor. These are pieces of information the legislature has determined rationally, we believe, to be in the public benefit and for public safety purposes. If the person doesn't register, if they don't tell the sheriff where they're living, they don't tell them that they're in the county, that information is not available to law enforcement should they need to conduct an investigation. That information is not available to the public for its purpose. The two things that I wanted to leave the court with are this question about the excessiveness of the retroactive application of the 2006-2011 amendments, and then one parting word on Doe. The state's point in our argument is that the retroactive application of these statutes is not excessive. Essentially, the requirements are the same that Mr. Redmond had when he was initially convicted for his 2001 sex crime. The duration has been extended, but the question is whether or not there's a reasonable relationship between the extension, the in-person reporting, and the public safety aim that we're trying to achieve. And the state submits that there is, because there's a longer period of time in which people will know where sex offenders like Mr. Redmond are located. And that serves a public safety benefit. The final point that I want to make is Justice Biles asked this question in the previous argument, which is whether or not we just need to look to Doe to make the decision. I've run out of time. May I conclude briefly?
Yes.
I would agree that this court should look very closely at Doe. My only caveat to that would be it's not a simple one-on-one comparison to the Alaska statute to the Kansas statute. Look at the reasoning of the court, because I think that supports finding that these statutes are not punitive in effect. Thank you.
Any questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.